Welcome to the second of the Week 7 podcast for Administrative Law. We're now moving on to jurisdictional error, which, as I said, is one of my favourite parts of administrative law. In this podcast, we will look at the significance of jurisdictional error for getting around privative clauses and the difference between jurisdictional and non-jurisdictional errors of law. Jurisdictional error is relevant to administrative law in two ways. First, it may be a freestanding ground of review under Section 51C of the ADJR Act or Section 21C of the Judicial Review Act. This provision applies where the person who purported to make the decision did not have jurisdiction to do so. You can use this freestanding ground of review in the same way you use the other grounds of review if there is no privative clause. Secondly, jurisdictional error is a fundamental ground of review under the common law. Jurisdictional error is grounded in the original jurisdiction of the High Court to issue constitutional writs under Section 75(5) of the Constitution. These writs are enlivened by jurisdictional error, and this is the ultimate trump card for applicants faced with a privative clause. Establishing jurisdictional error is essential in the context of an increasing number of privative clauses in legislation in recent decades. A privative clause is a legislative device which seeks to oust or restrict judicial review. It's an attempt by the legislature to say that certain decisions are not judicially reviewable. In an exam, a privative clause is what you look for as a clue that you need to use the common law avenue of judicial review and establish jurisdictional error. As we've discussed, your starting place would normally be the statutory avenue of judicial review, if it's available, because it is more user-friendly and it provides a right to a statement of reasons, etc. However, if there is a privative clause, you may have no choice but to resort to the common law avenue of judicial review. The question thus arises, what does a privative clause look like? An example of a privative clause is provided on slide 21. In 2001, the government amended the Migration Act again to seek to limit judicial review of migration decisions. Applications could be made to the High Court, the Federal Court, or the Federal Magistrates Court for one of the constitutional remedies, but these applications were subject to a privative clause. The Migration Act provided that, subject to certain exceptions, any administrative decision made under the Act is final and conclusive, must not be challenged, appealed against, reviewed, quashed, or called in question in any court, and is not subject to prohibition, mandamus, injunction, declaration, or certiorari in any court on any account. The problem with this privative clause is that it offends Section 75(5) of the Constitution. Section 75(5) grants the High Court original jurisdiction to issue writs of mandamus, prohibition, and injunction. As this authority is grounded in the Constitution, these powers can't be taken away by statute. We would need to change the Constitution by a referendum for a Parliament to be able to do this. This privative clause was actually at the centre of one of the most significant administrative law cases in recent decades, Plaintiff S157 of 2002 and the Commonwealth. The High Court held that this privative clause did not operate to prevent judicial review of decisions that involved jurisdictional error. Such decisions were not validly made under the Act and therefore fell outside the scope of the privative clause. As such, the privative clause did not operate to prevent the High Court from exercising its judicial review jurisdiction under Section 75(5) of the Constitution. And we'll look in more detail at the case of Plaintiff S157 in a moment. In order to understand the significance of Plaintiff S157 and why it's so exciting for administrative lawyers, you do need to understand the historical background. Prior to the key cases of Plaintiff S157 and Kirk, which we'll talk about later in this podcast, privative clauses could effectively oust judicial review. I have included this slide about the old test from Hickman, as it is a test you will probably see in the textbook and in some of the cases. Please note that, as I have indicated at the bottom of the slide, this test is now out of date. But it is important for you to know that from a historical perspective, the test in Hickman was very frustrating for many years. According to the Hickman principle, a privative clause was only effective to protect a decision from judicial review where that decision was a bona fide attempt to exercise power, did not on its face exceed the power conferred, and was reasonably capable of reference to the power. Under this test, sometimes privative clauses would even attempt to oust judicial review for decisions infected by jurisdictional error. It was frustrating as a decision might be clearly unlawful, but it couldn't be challenged until more recently due to the effect of the privative clause. It is little wonder that privative clauses were getting more and more popular, as it would certainly make government's job easier if they didn't have to worry about judicial review cases all the time. As I noted at the bottom of the slide, this is no longer the correct test since the High Court's decision in Plaintiff S157, so please be mindful of that in your exam answers. The Hickman case was reconsidered by the High Court in Plaintiff S157 of 2002. This was when things started to shift and get more interesting. The facts of Plaintiff S157 are that S157 was an asylum seeker who had applied for a protection visa which had been rejected. The decision rejecting the visa had been reviewed twice by the Refugee Review Tribunal after intervening Federal Court judicial review. After the second decision of the tribunal upholding the rejection of his visa application, S157 sought a declaration in the High Court that the privative clause in Section 474 of the Migration Act, which we looked at before, was unconstitutional as it prevented him from accessing the High Court's original jurisdiction pursuant to Section 75(5) of the Constitution. He claimed that he should be able to bring an action in the High Court's original jurisdiction for a decision allegedly tainted by a breach of natural justice. Specifically, it was alleged the tribunal took into account material directly relevant and adverse to the plaintiff's claim of refugee status without giving him notice of the material or an opportunity to address it. As we discussed in week 4, the right to respond to adverse information is one of the elements of the natural justice hearing rule. The High Court held in this case that a legislative privative clause cannot deprive the High Court of its constitutional judicial review jurisdiction conferred by Section 75(5) of the Constitution, or deprive federal courts of their Chapter 3 judicial power. This is because privative clauses are statutory devices, and as you will remember from constitutional law, statute law cannot be inconsistent with the Constitution. Privative clauses can be designed to protect against almost anything except jurisdictional error. This is because jurisdictional error enlivens the remedies in Section 75(5) of the Constitution, and statute law can't exclude constitutional protections. So what was the approach to statutory interpretation that informed the High Court's conclusion in Plaintiff S157? First, it should be noted that the Parliament's intention regarding the privative clause was pretty clear. The Parliament introduced this privative clause after the Tampa crisis with the explicit intention of restricting access to judicial review in all but exceptional circumstances. This was a response to a rapid increase in migration litigation. Despite the fact that the legislative intent was abundantly clear, judges have long responded negatively to legislative attempts to limit or exclude the scope of judicial review of administrative action. This is because, although there may be policy reasons for using privative clauses, they tend to offend the rule of law. The majority of the High Court, which consisted of Justices Gaudron, McHugh, Gummo, Kirby and Hayne, interpreted the privative clause in Section 474 of the Migration Act very narrowly, noting that there are two basic rules of statutory construction which apply to the interpretation of privative clauses. First, Commonwealth privative clauses should be construed consistently with the Constitution if such an interpretation is fairly open. And secondly, it is presumed that Parliament does not intend to cut down the jurisdiction of courts except to the extent that the legislation in question expressly so states or necessarily implies. In other words, there are constitutional requirements which must be considered in construing privative clauses. They cannot oust the jurisdiction given to the High Court by Section 75(5) and other paragraphs of Section 75, such as Section 75(3) concerning matters to which the Commonwealth is a party. Secondly, privative clauses cannot allow government decision makers to determine the limits of their own jurisdiction, as this infringes Chapter 3 of the Constitution. The Court also said that Section 474, subsection 1, cannot be read in isolation from Section 474, subsection 2, which talks about what is meant by the phrase privative clause decision. And we saw this definition on slide 21. In the earlier case of Bardwaj, which we talked about in week 4, the High Court held that an administrative decision infected by jurisdictional error is not, in law, a decision. So privative clause decisions under Section 474(2) must be decisions that are not infected with jurisdictional error. A decision involving jurisdictional error is not a decision made under this Act. Therefore, it is not a privative clause decision that is protected by the privative clause. A breach of natural justice can constitute jurisdictional error, which has previously been established in Ex parte Ala. Accordingly, the privative clause could not protect a decision from judicial review that was affected by a breach of natural justice that was sufficiently serious to constitute jurisdictional error. Would it make any difference if the privative clause explicitly stated that it precludes review of a decision affected by jurisdictional error? The answer is no. A privative clause cannot preclude review of decisions affected by jurisdictional error because review of such decisions is protected by the Constitution. So this case is really significant as it provides a limit on the extent to which the Parliament can erode administrative law protections. We can see this as a case in which the rule of law won over legislative overreach. Between 2003, when Plaintiff S157 was handed down by the High Court, and 2010, there was uncertainty as to what the legal position was in relation to privative clauses in state legislation. The writs in Section 75(5) of the Constitution don't apply to state privative clauses because state government officials are not officers of the Commonwealth. However, the High Court's ruling in the 2010 case of Kirk entrenched judicial review for jurisdictional error at the state level with reference to other parts of the Constitution. So this case is therefore like the state equivalent of Plaintiff S157. The facts of this case are that Graham Kirk was a director of the Kirk Company and owned a farm in New South Wales. The company employed another Graham, a Graham Palmer, who was an experienced manager and who ran the day-to-day operations of the farm. In June 1998, the company purchased an all-terrain vehicle on the recommendation of Palmer. In March 2001, Palmer used the all-terrain vehicle to carry some steel to fencing contractors who were working on the property. Instead of using a formed road which led to the paddock where the contractors were working, Palmer left the road and proceeded to drive down a steep hill. The all-terrain vehicle overturned and Palmer was unfortunately killed. Kirk and the Kirk Company were found to have committed offences under Sections 15 and 16 of the Occupational Health and Safety Act of New South Wales in the Industrial Court. There was a privative clause in the Industrial Relations Act of 1996 which purported to oust judicial review of decisions of the Industrial Court. Section 179(1) of the Act provides that a decision of the Industrial Court, however constituted, is final and may not be appealed against, reviewed, quashed, or called into question by any court or tribunal. As I said, before the case of Kirk, it was unclear whether this type of clause would be constitutionally valid in the light of the decision in Plaintiff S157. This was all clarified by the High Court's ruling in Kirk. The Court accepted that at Federation, each of the Supreme Courts referred to in Section 73 of the Constitution had jurisdiction reflecting that of the Court of the Queen's Bench in England, and that each accordingly had the power to issue the writ of certiorari to any inferior court. Remember that certiorari allows a decision to be quashed. This basically means that state courts can quash a decision of an inferior court in the court hierarchy if there is jurisdictional error. The supervisory jurisdiction of the Supreme Courts is one of the defining characteristics of those courts protected under Chapter 3 of the Constitution. Thus, an attempt to remove or limit the supervisory jurisdiction of the Supreme Courts through a privative clause is beyond the power of the state legislatures. This confirmed the position already recognised at the Commonwealth level by virtue of Plaintiff S157. It is also constitutionally entrenched that the High Court has power to superintend the supervisory jurisdiction of the Supreme Courts. The High Court will not countenance islands of power that are beyond its supervision or restraint. Basically, this means that at both the Commonwealth and state levels, a privative clause will not be effective if a decision is affected by jurisdictional error. According to the High Court, there were two jurisdictional errors of law that the Industrial Court of New South Wales made in this case. First, the Industrial Court misconstrued the Occupational Health and Safety Act. the Industrial Court failed to identify what measures Kirk could have taken to ensure the health and safety of the deceased farm manager. In addition, the Industrial Court did not identify any act or omission that amounted to a failure to ensure the manager's health and safety. In this way, the Industrial Court misapprehended the limits of its functions and power. This misconstruction led the court to make orders convicting Kirk and sentencing him when it had no power to do so, because it had not actually made the findings necessary to constitute an offence. In other words, an offence had not been proved. Common law principles support the proposition that a defendant is entitled to know not only the legal nature of the offence with which he or she is charged, but also the particular act, matter or thing alleged, which is the foundation of the charge. The Industrial Court's second jurisdictional error related to a breach of the rules of evidence. The Industrial Court is subject to the Rules of Evidence of New South Wales, including a provision that a defendant is not competent to give evidence for the prosecution. However, in the trial, the prosecution was allowed to call Mr. Kirk, the defendant, as one of their witnesses, contrary to Section 17(2) of the Evidence Act. The laws of evidence were described as a fundamental or essential condition on jurisdiction. In other words, by conducting a trial that was not in accordance with the laws of evidence, the Industrial Court misapprehended the limits on its power to hear criminal offences. So how did the High Court approach statutory interpretation in this case? The High Court construed the privative clause narrowly in a way that upheld the validity of that clause. However, it held that the Industrial Court decision should be quashed on the basis that jurisdictional error had occurred. In other words, the privative clause was valid, but it was not effective in this instance. The privative clause did not preclude review of decisions affected by jurisdictional error, as such decisions were not to be treated as decisions protected by the privative clause. This is because, as we saw in Plaintiff S157, an administrative decision affected by jurisdictional error is not, in law, a decision. So we have talked about jurisdictional error providing an important mechanism to get around statutory privative clauses. Now let's look more closely at what jurisdictional error is and how we can establish it. So what is a jurisdictional error of law? It is an error that the decision maker had no jurisdiction or legal authority to make, or it is an error that takes the decision maker beyond the scope of their legal authority. If there is a decision that is infected with jurisdictional error, it is treated as if the decision was never made. The law regarding jurisdictional error developed in connection with the common law prerogative writs of certiorari and prohibition, which we'll discuss further in week 9. Jurisdictional error is the only basis on which to invoke the constitutional writs before the High Court under Section 75(5) of the Constitution. As we have seen, jurisdictional error will mostly trump legislative privative clauses which seek to immunise administrative decisions against judicial review. And this was confirmed in Plaintiff S157 and Kirk. When thinking about jurisdictional error, there are two important distinctions to keep in mind. First, in Australia, we have retained the distinction between inferior courts and administrative tribunals. In general, the courts have held that inferior courts are less likely than administrative tribunals to commit jurisdictional error. Judges are legally trained and appointed in a particular way with long tenures, whereas administrative tribunals have non-legal members that are appointed for shorter periods, etc. This is one of the reasons why we have retained a distinction between the two. This also comes down to the separation of powers. The role of the judiciary under the Constitution is separate and distinct from the executive and tribunals. Authorities for this are the cases of Craig and South Australia and Kirk, and we'll look at the case of Craig and South Australia in a moment. Secondly, in Australia we don't assume that all errors of law are sufficient to constitute jurisdictional error. So there is such a thing as a non-jurisdictional error of law, which is an error of law that is not serious and fundamental, and therefore does not render the decision invalid. We'll look in more detail at each of these points in turn. The case of Craig and South Australia talks about what will constitute jurisdictional error by an inferior court and an administrative tribunal. The facts of this case are that a man named Craig was charged with offences in the district court. Craig applied to Judge Russell for a stay of proceedings because he could not afford legal representation and wanted to wait until legal aid could give him a lawyer. The district court judge concluded that the case of Dietrich and the Queen, which you may have studied in criminal law, required the trial to be stayed because Craig lacked legal representation through no fault of his own. The state of South Australia sought a writ of certiorari quashing this decision of the district court. South Australia argued that the judge's finding that Craig was without legal representation through no fault of his own was incorrect because he had in fact recently inherited $20,000. The question considered by the High Court was whether this was sufficient to constitute a jurisdictional error. The High Court said that it was not necessary to decide whether the judge had misconstrued the decision in Dietrich and the Queen. The court also said it was doubtful that the trial judge had made an erroneous decision, but more importantly, held that an error of the nature alleged was not a jurisdictional error, so certiorari was not available. Importantly, the High Court said that an inferior court will commit jurisdictional error in two circumstances. First, if it mistakenly asserts or denies jurisdiction. This is when it thinks it's got power to do something that it doesn't. For example, magistrates' courts do not have jurisdiction to sentence someone to jail for life. Only the Supreme Court can do this. Or if a court limited to hearing civil matters hears a criminal matter, this will constitute jurisdictional error. The second way an inferior court commits jurisdictional error is if that court misapprehends or disregards the nature or limits of its functions or powers after correctly recognizing the jurisdiction question. An example of this might be if an inferior court can only hear compensation matters under $20,000 and it hears a matter in relation to more than $20,000. The first question is, can it hear compensation matters? And the answer is yes. The second question is, what can it do within that jurisdiction? And the answer is that it can't exceed the $20,000 limit. The significance of the case of Craig and South Australia is that a jurisdictional error of law has to be pretty major if the decision maker is an inferior court. But it's easier to establish for a tribunal or an administrative decision maker. In other words, we can say that in general, inferior courts are less likely than administrative tribunals to commit jurisdictional error. This means that the broader categories of jurisdictional error, based on natural justice, etc., are unlikely to apply to an inferior court matter. In relation to administrative tribunals and other executive decision makers, jurisdictional error goes beyond this. In addition to the above, it can be based on irrelevant considerations, a failure to consider relevant considerations, a breach of natural justice, asking the wrong question, and identifying the wrong issue. Administrative tribunals and decision makers are therefore much more likely to fall into jurisdictional error. As we said in relation to the second point on slide 33, in Australia we don't assume that all errors of law are sufficient to constitute jurisdictional error. So there is such a thing as a non-jurisdictional error of law, which is an error of law that does not render the decision invalid. This may be because it is trivial or immaterial. Only serious or fundamental breaches will be sufficient to constitute jurisdictional error. Craig and South Australia and Kirk both look at what is and is not sufficient to constitute jurisdictional error. The courts have struggled to articulate the modern relevance of the distinction between jurisdictional and non-jurisdictional errors for a number of reasons. First, there has been a proliferation of new decision makers, and there is no clear distinction between courts and others. Secondly, the concept of jurisdictional error has changed, and in particular it has expanded. Thirdly, all grounds of review are presumptively available against all kinds of decision makers. The distinction between jurisdictional and non-jurisdictional errors has been abandoned in some comparable jurisdictions. In the United Kingdom, for example, they have the anismonic doctrine, which means that all errors of law amount to jurisdictional error. This means that all the grounds of review, such as a breach of the rules of natural justice, bad faith, a failure to consider a relevant consideration, are all reviewable for jurisdictional error. So if you think about all the grounds we've talked about in the previous weeks, these are all legal errors that amount to jurisdictional error in the United Kingdom. There is no distinction in this regard between administrative tribunals and inferior courts. This is not the position in Australia, although it would be a lot easier if it was. Some Australian judges have argued that we should do the same, but the High Court has so far refused to do so. In Australia, we don't say that all errors of law constitute jurisdictional error, but it's not 100% clear exactly what does and what does not. For our purposes, it is sufficient to note that in Australia, the concept of jurisdictional error is broadly defined and is expanding. And it is very likely that the error of law is a jurisdictional error, particularly if the decision maker is an executive officer. But in an exam you still need to argue this rather than just to assume it. So what you need to do is start with the recognised categories of errors of law that constitute jurisdictional error, and then argue by analogy. We'll speak more about this in the rest of this podcast and in the Week 9 podcast. How then do we work out what constitutes jurisdictional error in Australia? Distinguishing between narrow and broad types of jurisdictional error is a helpful method of classification, but note that this is not a legally binding distinction. Historically, the narrower type of jurisdictional error referred to a lack of jurisdiction. This means there was no jurisdiction at the outset. That is, the decision maker is in the wrong territory, which is a threshold issue. In other words, the decision maker was making a decision that they had no authority to make. The decision maker should not have seized authority to make this decision. An actual example of this was Coco and the Queen, where there was a warrant for a listening device but no warrant for a trespass. You may recall from our discussion in week 5 that Coco was importing illegal drugs and the authorities sought permission from the Supreme Court to use a listening device. This permission was granted, but permission to place the device in Coco's office was not granted, as this was private property. As the legislation did not specifically say that the installation of a listening device on private property was valid, all the information obtained through this listening device was invalid. If there is no authority to make a decision, this means that the decision will be infected by jurisdictional error. The broad type of jurisdictional error occurs where there is an excess of jurisdiction. Some commentators disagree about the scope of this type, whereas there is broad agreement regarding the first type of jurisdictional error. Broad jurisdictional error occurs where the decision maker enters the correct territory of the decision. They have correctly seized jurisdiction, but then they commit a fundamental error. The question is, how bad does the error have to be? Is a failure to take into account a relevant consideration, a breach of natural justice, or unreasonableness enough? Some cases have found that it is. If it is a fundamental or serious error, a breach of one of the other grounds of review will normally constitute a jurisdictional error. This is still a controversial area, and there is no shopping list of what will constitute a jurisdictional error. It is still being developed under the law. As I mentioned to you earlier in the semester, the normal structure for thinking about problem questions in administrative law is to think about threshold issues such as justiciability, jurisdictional prerequisites and standing, then establishing at least one ground of review, and then thinking about remedies. If there is a privative clause, you need to structure your answer to the problem question differently. I'm going to show you this mind map now, and then we'll unpack this further in the Week 9 podcast. This mind map may be a helpful way to structure your thinking around jurisdictional error. If there is a privative clause, you need to establish jurisdictional error to get around it. There are two ways you can do this: by establishing either the broad or the narrow type of jurisdictional error. You would typically start with the narrow type of jurisdictional error because it's easier to establish. These are the types of decisions I was talking about before, where the decision maker was making a decision that they had no authority to make. The decision maker should not have seized authority to make this decision. After you've considered narrow jurisdictional error issues, you can consider broad jurisdictional error issues, which is where the decision maker enters the correct territory of the decision, but then commits a fundamental error. There can be recognized categories of broad jurisdictional error. For example, last week we talked about Miak and Lee, where unreasonableness was recognized as constituting a broad type of jurisdictional error. However, as we said, in Australia, it is unclear whether all grounds of review will constitute jurisdictional error. So this needs to be argued based on the statute in question and by analogy with the established categories of jurisdictional error. As I said, jurisdictional error can be a tricky topic, and if it doesn't make complete sense now, don't worry, because hopefully it will all become clear when we unpack this further in week 9, and then we will also practice applying this methodology in the tutorials. So this brings us to the end of our second podcast. Let's look at one revision question on jurisdictional error before we finish. The question is, a privative clause that seeks to completely exclude the Judicial Review Act or the ADJR Act will only be successful where A. There is a complete absence of jurisdiction, B. There is neither broad or narrow jurisdictional error, C. There is broad jurisdictional error, or D. There is narrow jurisdictional error. What do you think? The answer is B. A is incorrect. This is one example of narrow jurisdictional error, which means the privative clause won't be effective. B is correct. A narrow or broad jurisdictional error will invalidate a decision even if there is a privative clause. If there is no broad or narrow jurisdictional error, the privative clause can be effective. C and D are incorrect, as if there is either broad or narrow jurisdictional error, a privative clause will not be effective in precluding judicial review. So this brings us to the end of the Week 7 materials. Just a reminder that there are no administrative law lectures or tutorials next week, as this is the week that your assignment is due. Both lectures and tutorials will resume as normal in Week 9. Thanks very much for your engagement, and I'll see you in Week 9.